You might think, if I were to ask you, is it too late at that point for Congress to stop the U.S. Supreme Court from issuing an opinion and judgment in a case? You might say yes, and by the way, that's the only thing that was left for the court to do. The only thing it hadn't done yet was actually issue its opinion and its judgment. It would be sort of common sense answer to say, well, that's an abuse of Congress's power. Now, by the way, put these words in your notes. Jurisdiction stripping. That's what this is called. Jurisdiction stripping. That makes sense. It's Congress taking away jurisdiction of federal courts in cases where Congress doesn't want federal courts addressing those issues. As a historical matter, it's likely that the reason Congress got away with it in this case was because, again, this does seem like a little bit of an abuse of the jurisdiction stripping power. The reason Congress got away with it in this case was that the Supreme Court, as I discussed earlier, didn't want jurisdiction in this case. They were eager for Congress to take away their jurisdiction. What's the upshot? The rule out of Ex parte McCardle, and this rule has been limited by the next case we're going to discuss in the next video called Klein. The rule that emerges from Ex parte McCardle is that Congress may remove the appellate jurisdiction of the Supreme Court to hear a class of cases at any time as long as the Supreme Court has not, remember this, as long as the Supreme Court has not already issued its opinion and its judgment. Obviously at that point, once the Supreme Court has decided a case, at that point, Congress trying to mess around with the court's jurisdiction would be a clear violation of separation of powers principles, would be a clear attempt by Congress to interfere with the exercise of judicial power. So where are we in terms of jurisdiction as a constitutional matter under Article 3? Congress is not allowed to mess around with the original jurisdiction of the Supreme Court. The original jurisdiction of the Supreme Court is set in Article 3 and cannot be changed. There's an important principle at work here. Congress may not change the Constitution with a mere statute. Changing the Constitution requires a constitutional amendment. We'll talk about that later. But a mere law passed by Congress is not going to get the job done. Cannot change the Constitution by statute. So if the Constitution says, here's the original jurisdiction of the Supreme Court, Congress can't come along and pass a law that changes that. However, the Constitution in Article 3 does give Congress, explicitly gives Congress the authority to regulate the appellate jurisdiction of the Supreme Court. We'll talk about lower courts in the next video, but that's where we are so far. Congress is not allowed to mess around with the original jurisdiction of the Supreme Court. Congress may regulate the appellate jurisdiction of the Supreme Court. When? It may do that at any time before the Supreme Court issues an opinion and judgment. At the time the Supreme Court issues an opinion and judgment, it is too late. That would be an abuse of jurisdiction stripping power and a violation of separation of powers principles. So that's Ex parte McCardle. I hope those rules are clear. We will next move on to the Klein case, where the court made clear that there are limits. Congress cannot go too far with its jurisdiction stripping. So back with that later. Stay tuned and stay well.